Oh my god. It helps if you actually get the microphone out and you actually do the freaking things. Ladies and gentlemen, we're getting started big, and thank you very, very much for the raid. That's really exciting. I'm really excited to present Manic Monday with Manning again for the third time straight. We're going right into it as soon as it's time to get started. It's time to get started. We got 30 seconds left, ladies and gentlemen. It's going to be a good one tonight. It's going to be a little bit of a long one, but it's going to be a good one.
You don't need to tell your mother what I said. Get back on this screen. Turn your camera on now. Send them out of the room. Send those two girls out of that room now. Don't say a word. Just send them out of the room. Oh, and go ahead and put yourself on mute now. I can't. I've only got 10,000 until I need one. All right, let's see. So we got Lamar Allen, position 16. Ms. Jackson, you ready?
Yes, Judge.
All right, Bostic, position 16, Lamar Allen, 24 PI 003254. As of June the 3rd, there's a $10,000 good bond on aggravated assault, 97 days without indictment. Wow.
20 cycles in Texas, a harassment of a public servant in 2014, obstruction in 2022, felony and evading arrests that are old. In Georgia, 8 cycles. Doesn't appear to have felonies here. Simple battery and FTA in 2018. Nothing further.
All right, Ms. Murray, it looks like he lives in Stone Mountain.
Yes, Your Honor.
Okay, go ahead, Ms. Murray.
Thank you, Your Honor. Mr. Allen is 37 years old. He has resided in Georgia since 2016, and he does have family here, his father, aunts, and uncles. He's a high school graduate, and prior to his incarceration, he was employed doing construction and warehouse work. Mr. Allen does suffer from substance abuse issues, and so we reached out to Hope House and were able to get him accepted into their program, so he would be able to participate in their residential treatment program and receive some assistance with those substance use issues. We'd like to point out that this count of aggravated assault involved a knife, not a firearm, and the alleged incident is kind of in line with the fact that Mr. Allen is dealing with some substance use issues. So we think that the residential treatment at Hope House will reduce the risk of any further incidents such as this. No one was injured during that incident as well, Your Honor. We're going to ask that bond be reduced to $2,500 in this case. That'll put Mr. Allen in bail project range, and also he may have family that would be able to afford a bond of that amount.
Is Hope House in Fulton County?
It is.
Okay. All right, go ahead, Ms. Jackson.
Judge, the state would oppose reducing this bond to something as low as $2,500. I do understand that Mr. Allen's criminal history is comparatively low here in Georgia, but Mr. Allen has a pretty extensive and pretty alarming history out in Texas. Ms. Bosick was being very modest when she described these incidents as old. While they do date back to 2009, Mr. Allen has a 2009 resisting arrest, 2009 evading arrest, 2012 escape from custody, 2012 resisting arrest, 2013 evading, 2014 resisting, 2014 harassment of a public servant, and then 2016 resisting arrest. Then his criminal history immediately picks up in Georgia, where he has an aggravated assault or stalking that was reduced to a disorderly conduct, some issues out of DeKalb County with no disposition, in open cases, including obstructions that are similar to the allegations and convictions out in Texas. For that reason, the state believes that Mr. Allen is an extreme flight risk. He's unlikely to return to court, at least without some type of force from someone when called. We do believe that Mr. Allen is likely to reoffend based off the pattern that is displayed in his criminal history. And based off of the history and the allegation of violent stalking, disorderlies, batteries, and harassment of public officers, we would say that Mr. Allen is a danger to this community and the law enforcement community. The state will request that it stays at 10,000.
All right. So, Ms. Rivera, has there been any contact with the Xavier Alexander, the alleged victim?
Good afternoon, Your Honor. I tried to get in contact with the victim, but the phone was not a working number.
All right, thank you so much.
You're welcome.
Right. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay away from all MARTA property. That includes bus stops, sir. You cannot sit down on a bus stop bench and tie your shoe. That'll be a violation of your bond condition. Stay away from 1055 DeKalb Avenue, including all MARTA property. No further contact with Xavier Alexander, and that is the Inman Park MARTA station. Xavier Alexander, all right? You live in Stone Mountain, so unless you attend and complete the inpatient at Hope House, you got to stay out of Fulton County unless you're here for court or to see your lawyer. You can participate and complete the inpatient at Hope House, but if you're not doing that, then you need to stay out of Fulton County. I'll make it a $7,000 good bond. Best of luck to you, sir. Let's see who is anybody force out. You can leave the booth. Let's see, Anthony Wilder.
Yes, Your Honor.
All right, let's see, Anthony Wilder. Let's see. All right, Anthony Wilder, raise your hand, sir. There we go. All right, so it's position 2, 24 PI 003373. Anthony Wilder, 94 days without indictment as of June 4th. There is a $30,000 good bond on possession of firearm by a convicted felon and reckless conduct. Wow.
Anthony Wilder, Judge, FTA in 21, 16 cycles, on probation out of Cobb, theft by receiving felony, fleeing and eluding, sentence 5-1-24, 5 years. 2 other felonies that's old for burglary and theft by receiving, nothing further.
All right, go ahead, Ms. Guest.
Yes, Your Honor. Mr. Wilder is before you today. He's 34 years old and has been a lifelong resident of the Atlanta area. He does have a valid address where he would reside. He plans to reside with his sister in Fairburn, Georgia. He also, while he's been incarcerated, has stated to me that he's been accepted to the We Are Living Proof program. So I don't know if they actually are going to set him up with some type of housing on his own in Fulton County. So I would ask that the court considers not placing any restrictions on Mr. Wilder that would prevent him from potentially eventually residing in county of Fulton County once We Are Living Proof hopefully gets him set up on in a place of his own. He has been in custody for over a year in Cobb County, and these are so the court is aware older warrants that came up when he was being processed out of Cobb County, Your Honor. But since he's been incarcerated for over a year, he does not have employment, but does believe that once he is able to be released from custody, he would have the opportunity to actually begin working again. He does have 4 children, and just as of late, his 2 twins who are 7 months old when he was brought here in Fulton County, they're turning 1 in September. However, they are one of them is currently hospitalized, and prior to being incarcerated, Mr. Wilder was slated to financially support those children. Again, Your Honor, he hasn't really been able to be there for his smaller children since he has been incarcerated for over a year. But seeing as though they are children that have taken ill, it is important to him to be able to be released so he can be with his children. Because currently, right now, I believe that his father is caring for those 2 young children. Your Honor, we would just ask that you consider a reduction in the bond. Mr. Wilder did waive his preliminary hearing to get a consent bond, but since he's been in custody, his family has not been able to post the bond as it currently stands. We're asking for a bond not to exceed $10,000 on count 1 and $10,000 on count 2, Your Honor.
All right, go ahead, Ms. Jackson. Has there been any, oh, I'm sorry, Ms. Rivera, has been any contact with any of the 1, 2, 3 alleged victims?
Give me 1 second, hold on.
Okay.
No contact, Your Honor.
All right, go ahead, Ms. Jackson.
Judge, the state is requesting that the bond in this case be kept at $30,000. We believe that Mr. Wilder's bond of $30,000, which is 15 on each, is incredibly reasonable. In fact, the state would ask that since this is for a motion for reconsideration, the court consider raising the bond in this case. The facts of this case are quite frankly egregious, and I'm quite frankly confused as to why these are the only 2 counts that are on the calendar. A quick reading of the warrant says that Mr. Wilder got into an altercation with some women in a hotel room. was asked to leave, refused, eventually left, but came back with a firearm, sat in the doorway of the hotel room and fired shots into the room. He actually struck one victim multiple times and struck another victim. Eyewitnesses say that there were multiple children and women in the room when he was firing inside of it. Mr. Wilder is also a convicted felon based off of a 2008 burglary, so was not supposed to have a gun in the first place. The facts of this case are quite frankly reflective that Mr. Wilder is an extreme danger to the community. He's an extreme danger to these victims. And Judge, we would ask that the bond stay at $15,000 each, or if the court is inclined, raise it.
Your Honor, I would just like to correct the record because I did prepare for this preliminary hearing. It just was Mr. Wilder's position that he would prefer just to consent to the bond, but the warrant does not state that Mr. Wilder was the individual that allegedly came to this hotel allegedly with a firearm. It was actually a Mr. Trey Taylor, which is the alleged individual that got into an altercation with a woman at a hotel room and then later came back with a firearm. And as you can read in the warrant, it was Mr. Wilder who actually defended these individuals, which is why he wasn't charged with the additional charges. But nonetheless, this is not a preliminary hearing. It's just about whether or not Mr. Wilder is a good candidate for bond based off of the Ayala factors, Your Honor, and based off his likelihood to reoffend. Did not appear that pretrial indicated any charges or convictions that resembles these, Your Honor, which goes to the likelihood to reoffend. He has not been charged previously with being a felon in possession of a firearm, Your Honor. We would just ask that the court takes that into consideration. Again, this isn't our opportunity to go into the facts of the underlying case because this isn't his preliminary hearing.
All right, let's see. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. No further contact with Denine, Denine, Brand, Brand, or Lisa Bateman, Batman, or Natasha Savage, Savage, and no further contact with Trey Taylor, Tray, alleged co-defendant or co-conspirator, but no further contact with Trey Taylor, excuse me. All right, stay away from 4874 Old National Highway in Atlanta, Georgia. You're going to have a 24-hour curfew except for court, lawyer, see your lawyer, medical appointments, and work. But you have to supply the name of your employer, proof of employer schedule, and the exact location you'll be working, or you will not be able to leave your house, sir. Make sure you keep your address updated with your attorney so she can keep it updated with the court. And I'm only going to reduce it to 14 and 14. Best of luck to you, sir. You can leave the booth. See
Your
ya.
Honor, that concludes my matters with the court. May I be excused?
Yes, ma'am. Have a good evening.
Thank you, Your Honor.
Demario Price. Wave your hand, or there you go. Thank you, sir. All right, we got position 12, Bostic 23, CP 224142, 243 days without indictment, $20,000 good bond as of June 18th on criminal damage property, second degree. Rah.
Cycles on probation for tools, firearm during firearm by sentence 3/2/23, 2 years confinement, 3 years probation. Also for marijuana with the intent, sentenced in 2017 for 7 years. First offender aggravated battery, sentenced in 2017 for 9 years. There's a 2019 criminal damage to property, purchase, manufacture, and sale. 2017 purchase, manufacture, and sale, firearm during. Nothing further.
All right, go ahead, Ms. Murray.
Thank you, Your Honor. Mr. Price is 25 years old. He just recently had a birthday in jail. He's been in custody for 242 days for one count of criminal damage to property in the second. He is a lifetime Georgia resident. His entire family lives here, and he does have a good address where he can reside. He has already served out an 8-month probation revocation sentence and is still in custody on these charges. The district attorney's office has been doing a great job indicting some of these older cases, so I'm not sure why Mr. Price's is lingering. However, he cannot afford the $20,000 bond, and given the amount of time that he's been in custody, we would ask for a reduction to $10,000. And we'd also ask if there's been any alleged victim contact at this rate.
Is he gonna live in Fulton County?
Yes, Your Honor.
All right, Ms. Rivera, been any victim contact with, I've got 2 victims here.
Hi, Your Honor. Yes, Miss Smalls, I spoke with her. She has no opinion on bond. She does want a stay away order.
Okay, all right, go ahead, Ms. Jackson.
Judge, honestly, the facts of this case are kind of alarming as well. The warrant is alleging that Mr. Price may or may not have been in some type of relationship with one of the women in this case and forced his way into the house and then into the bedroom. The criminal damage to property stems from damage to the doors. Judge, there was a TPO that the victim had taken out against Mr. Price at the time. However, the warrant notes that Mr. Price had not been served with that warrant. Judge, the most alarming part about this particular case is the fact of all the cases that Mr. Price was on probation for at this time. He does have a 2017 aggravated battery, which gave him 9 years of probation, which means his probation doesn't end until 2026. He does have a 2017 firearm, drugs, weapon without a license. He is still on probation for that. He does still have open 2019 cases. He has a 2023 case that he's still on probation for. And so, Judge, I'm not sure what conditions this court can impose that would keep a victim safe from Mr. Price if he wants to get inside of their home or inside of their bedroom. For that reason, Judge, the state believes that $20,000 is reasonable. There was just a hearing on this where he was granted the $20,000 bond on June 8, 2024. The defense has not described or shown any type of change in material facts that would warrant some type of decrease in the bond at this point. And so the state will request it to stay the same.
And Your Honor, if I may respond, in regards to the facts of this case, a preliminary hearing, it was established that after the police were called, it took about 10 minutes for them to arrive. And when they arrived, Mr. Price was allegedly sitting on the couch inside the home. There was no allegation that he did physical violence in that period of time, that he certainly had the opportunity to do so while he was inside the home. So we would ask that the court take that into consideration. In addition, I don't understand this continuous argument about no change in circumstances. The change in circumstances is that he's been in jail for an additional 2 months without indictment. So we would ask for that reduction to $10,000.
And Judge, real quick, respectfully, being in jail for 2 extra months below the statute of limitations is not a legal change in requirement, which is what's required in this type of hearing. And also respectfully, the fact that Mr. Price was still sitting on the couch of the home that he had just broken into when the police arrived is not a fact that would benefit Mr. Price.
Well, it benefits him in the sense that he did not attempt to flee the police. And since being a flight risk is such a concern of the state, I think it establishes that he's not.
It is a concern, and so is breaking into people's homes.
All right, no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons, no further contact with Ava McCarty, McCarty, or Shaisha, ShyESha Smalls, SMALLS. Stay away from 3145 Jonesboro Road. Let's see what's up in here. If it's available, you're gonna have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, and medical. If it's not available, sir, you're still gonna have that 24-hour curfew. You can leave your house for court, lawyer, medical. Is he gonna get a job, Miss Murray?
Yes, Your Honor.
And employment, but if you have to supply the name of your employer, proof of employment, schedule, and the exact location you'll be working. I'll put all these on my email tonight to the state. I'll make it an $18,000 good bond. Best of luck to you, sir. Let's see, who do we have in? Oh, let's see. I think that's your person, Mr. Showalter. Are you Mr. Montavious Merritt? So, sir, they addressed your bond on August the 7th. I think Mr. Showalter said it was $2,500. It's a $2,500 good bond, sir. So we're not going to address it again tonight, okay?
And Your Honor, that concludes my business. May I be excused?
Yes, ma'am. Thank you. So you can leave the booth, sir. All right, let's see. I got Miss Fletcher, Danana Fletcher, position 1, 24 PI 003-383, 93 days without indictment. I got a $12,000 good bond as of June 5th on kidnapping and theft by taking felony. Wow.
Your
9
Honor,
cycles, 2
I
FTAs,
don't
23.
see Danana Fletcher.
She's right there in courtroom 3.
Quorum 3. Okay, yes, very telling almost. Got it. Okay.
All right,
Thank you.
9 cycles, 2 FTAs, 23 and 19, probation for meth, 40 days confinement, 2 years, 10 months, 20 days, nothing further.
All right. Go ahead, Mr. Showalter.
Okay, so Dewana Fletcher, she is 23 years old. If released, she would be going to 2001 Sylvan Road, apartment 19D, Atlanta, Georgia. She would be living there with her mother. She has been in Atlanta her entire life. She's got a GED and 2 children, the subject of this case, and she was previously working at Publix, but obviously doesn't have work now, but she really wants to go and get some work. They have her there at the Fulton County Center due to some medical issue with her leg. And today she was telling me while she was over there at Grady yesterday, she saw, oh, they're holding a hiring event. I should go and apply. She wants to get right back to work. And she, I gave an address that would be her immediate address. If she was released, she would be going straight to her mother's, but we are working on helping her find stable housing. This is something else she's taken the initiative to get done herself. She wants a stable life. She is trying to go through rehab for some previous drug issues that she had as well. So we got a lot going for her to get her back on track. And I also want to address the court because one of her charges is kidnapping. That's one of those charges that's really broad. The underlying offense is that they're saying she took her biological children when defects. They are saying, we got our own argument, but they're saying she was not supposed to have her children at the time. So she drove off with her kids. That's the offense. There's no guns, knives, violence involved here. That's what was going on here. She has a total of a $12,000 bond, and to help her better get back on track, I really want this lowered down to something more manageable for her. I would like to see the kidnapping charge at $4,000 and theft by taking at $1,000.
So there is an open defects case?
Yes.
Okay. All right, Ms. Jackson.
Judge, without knowing any of the details of the open defects case, the position that the state would take is that the bond is reasonable. As Mr. Showalter stated, it doesn't state in the warrant, but it does appear that these were Ms. Fletcher's own children. It does say that there was a safety plan in place that Ms. Fletcher was not to be left alone or in the with the children or in the physical custody of the children, but when she waited until the grandmother was asleep and then took the children. For that reason, Judge, I do believe that $10,000 and $2,000 is appropriate. The state would not disagree to a reduction to $1,000 on the theft by taking, but would leave the $10,000 for the kidnapping and the discretion of the court.
All right. So Ms. Safarasi, I hate to jump my own. Ms. Safarasi, were all of your clients' cases indicted under those two? Because I only see 2 with SC numbers.
Yes, Judge, I double checked. They closed out all of 7 and indicted them all together in one case number.
All right, so they got.
So he can be, he doesn't need to be heard tonight because all of his cases are indicted now.
So 5 through 11.
Yeah, sure. All the cases on the calendar are indicted, Judge.
All right, 5 through 11. So I just saw 2 indictment numbers. So
I double checked on jailing. It's not updated properly, but if you look at the cases, they're all closed out. And then the indicted case, they did an indictment merging all the different.
okay, I just want to make sure because I just saw the 2. All right, so
I double checked, Judge. It's
I'm
good.
screaming later saying, "Oh, yeah." All right. So, Ms. Jackson, positions 5 through 11, they were indicted. So that's all one for. All right, thank you. All right, so Thank you, Ms. Alfrossi. You have one more, I understand. All right, so this is no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay away from 3400 Creek Point Drive in East Point. That's the Courtyard Marriott. No further contact with Ingrid Tyler, Sophia Baker, Victoria Fletcher, or Phoebe Griffiths, Griffis. Any contact with the minor children will be governed by a juvenile court order. Because if there's reunification, Ms. Jackson, juvenile court orders it, and so we'll put that. They'll be governed by juvenile court order. So we'll do 8,000 and 1,000. Best of luck to you, ma'am. All right, last one. All right, Miss Alfrossi, I never get it. Well, that's not him yet. We got, let's see, Montavious Mallerie.
Yes, Your Honor.
All right, so we got 23 CP 220425. I'm sure it's not just on this one because this one's in custody. 911 days without indictment, a $7,500 good bond as of April the 15th on aggravated assault, riot in a penal institution. Rah.
Sentence, I guess, since he's been in custody on street gangs, sentence 1/5/24, 1 year confinement, 9 years probation, 23 SC 190755, 6 cycles. There's an aggravated assault, 2 counts, death by receiving out of the cab, 2019 arm. He has a hold from 1/2022 for public peace. Nothing further.
Go ahead, Mr. Lee.
Yes, Your Honor. He is he's been in jail 800 days for this right in the penal institution. He was originally arrested for the gang charge that she referred to. That case has been resolved, Your Honor. We resolved that case last year. So now he's sitting inside of Fulton County Jail for a riot in a penal institution that, according to the facts of the case, the victim himself does not know who hit him. He said he didn't say he specifically said that he don't know who hit him or what happened, Your Honor. There are no witnesses who saw the incident. And as you know, this is a jail fight. So if there are no witnesses now, it's unlikely that witnesses will come forward as further this case gets, Your Honor. It's been 800 days Mr. Mallerie has been inside Fulton County Jail. In that time, he has seen over 12 inmates die inside of that jail facility, Your Honor. This is our second time in front of you making this argument when you drop the bond down to 7,500. I argued for a lower bond, saying that his family could not afford it. His family still cannot afford the $7,500 bond, Your Honor. We're asking that you drop this to something far lower, almost, I want to say a UJR bond, Your Honor, but if that's not possible, at least $2,000 so he can afford to pay this bond and move on with his life. As you know, Your Honor, he has a hold on his account. So once he pays this bond, he still has to go to Gwinnett County, then to DeKalb County to face the rest of these charges. So right now, he's just sitting. Time is passing him by, and he's still stuck in the same spot. Last week, we had an indict or release hearing, and they referred to the bond hearing that we have today, hoping for some type of relief for Mr. Mallerie, Your Honor. They said there's no reason to just release him just for no cause. So we're asking for some type of remedy that could help Mr. Mallerie continue with his life and get out of this same position. Again, the victim himself is not going to come forward. He doesn't know who hit him. He made those statements. There are no other inmates who saw Mr. Mallerie doing what's alleged of him. So if this case is indicted, we'll fight it. We'll file our motions to have this case dismissed. But since it's just sitting in the unindicted case, there's nothing we can do at this point, Your Honor. So our only relief is coming to you asking for a reasonable bond, something far lower so Mr. Mallerie can continue with his life. Thank you.
He's going to live in Decatur, right?
Yes, Your Honor.
All right, go ahead, Ms. Jackson.
Judge, I'm seeking a little bit of clarity. I see Mr. Markley said that Mr. Mallerie has been incarcerated on this charge for 800 days. I have the date of incident as July 2nd, 2023.
Right.
So the gang charges occurred first. He was in jail for the gang charges. He later was charged with the riot in the penal institution. In between that time, we resolved the gang charges case. That case is already resolved. So now he's only sitting inside of Fulton County Jail for this one riot in the penal institution. The original case he was arrested for has been resolved already.
Right. All she's saying is he hasn't been in 911 on this because this incident date was in July last year.
Yes, Judge, and I did just want to point that out. The state is, I guess, sympathetic to the fact that Mr. Mallerie is still incarcerated, even though he's resolved all of the cases that got him incarcerated in the first place. But Judge, this whole incident was captured on video. The warrant shows the officer describing exactly what happened by viewing the videos. But the fact that other inmates are not going to come forward and essentially say they saw it is really of no concern to the state at this point and doesn't change the facts of the case. Again, the facts state that Mr. Mallerie came up behind another inmate and started beating him with a broomstick, which did cause lacerations to his head. $7,000 on an aggravated assault, $500 on a riot in a penal institution is more than reasonable. Mr. Mallerie is likely to reoffend. We heard his criminal history. He's got cases that he just resolved while he was incarcerated, other aggravated assaults, other gang cases, an armed robbery from 2019, a first offender 2019 with aggravated assault ×4. So, I mean, the likelihood is that he's going to reoffend once released. Judge, Mr. Mallerie is a danger to the community. That will be both inside of the jail and outside of the jail based off the facts of this case. He's potentially a danger to the victim, both inside and outside of the jail. And Judge, we would believe that $7,500 in this type of situation is more than reasonable. I do want to point out that on August 8, 2024, Mr. Mallerie did go before Judge George on a motion to release or indict. Judge George did deny that motion and did state in her order that the bond that was set at $7,500 was reasonable under the circumstances.
All right.
And Your Honor, if I may respond, Your Honor, and rebut one point that the district attorney stated. She said that it's not important to them whether the inmates come forward, but it is highly relevant to this case if these are witnesses that we're referring to. So if there is a video, there are no witnesses who can talk about the video except for one officer to come forward. So if the victim himself is a witness, if he doesn't say that Mr. Mallerie hit him, there's no case to be had, Your Honor. And this case will eventually be resolved. But since this case is unindicted, I don't control whether this case is indicted or not. We ask that this case be indicted or release him. The motion was denied, Your Honor. So we're asking for some type of movement or some type of remedy from the court so Mr. Mallerie can continue.
All right. So I send an email and I'll copy you on it, Mr. Lee, every night with like how long people have been in jail without indictment. I send that to the state and I'll copy you on it this evening. And it's kind of giving them some guidance. So they've been indicting these. All right. We're going to, sir, you're going to stay out of Fulton County. The only reason you come to Fulton County is court or to see your lawyer. No other reason for you to darken the door of Fulton County. All right. You're going to have no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons, no further contact with Ishmael, last name Murillo, Murillo. Murillo, replicas of weapons in there. That would include shanks in the event you get a hold of one of those. Hopefully you won't. All right. So like I said, stay out of Fulton County. You're going to have a 24-hour curfew, court, lawyer, and medical. The only reason you can leave your house, of course, if you're on probation, that would include court or any of those things that you have to do. So I'll do 3,500, 3,500. Best of luck to you, sir.
Thank you, Your Honor. That concludes my matters. May I be dismissed?
Yes, sir. Have a good one.
Thank you.
All right, Richard, tell me one more time, Miss Alfarasi.
Esmond, Judge.
Esmond. Okay, you always help me with that. Position 4, last one, 23 CP 222774. 413 days without indictment. There is a $29,500 good bond as of June the 5th on aggravated assault, aggravated battery against law enforcement, disorderly conduct, willful obstruction, felony. Pre-trial.
18 cycles history of theft by shoplifting, PI, and 22 other case that was on the calendar before. 24 SC 002228, false imprisonment, criminal attempted felony, 2 count burglary, simple battery, assigned to Judge Cox. Nothing further.
All right, go ahead, Ms. Alfarasi.
Thank you, Judge. Mr. Esmond is 28 years old. He spent his whole life here in Georgia. He currently resides in Clayton County. We do have a good address for him. His whole family lives here in Georgia. We do have some MH issues, Judge, but he's been treated in the jail. He's been in custody now 413 days without an indictment on this case. A little bit to explain about his case was The first case, the 24 SC number that Vostick read out for us, that was the first case that got him booked into the jail. Then he picked up this case. This is a jail incident case that's on the calendar before you. The first case was indicted recently. That is, I don't know if you remember, Judge, you actually handled that preliminary hearing. We got some of the charges dismissed. They end up re-indicting them back. So we're having to deal with that again. I'm staying on this case, so we're working through that. That's assigned to Judge Cox, as you heard. He is a high school graduate. He was attending the NASCAR Technical Institute at the time of his arrest. He just needs one more year and he'll get his certification. Judge, and then he also works he also works with his father's business. They sell some things. And so, Judge, this current bond on this case is $29,500. The bond on the other case is $14,000. I'm just asking you to bring this down to a $15,000 bond. We think maybe 30 could be doable. And just because of the sheer fact that it's been 413 days, I'm asking you to reduce in half, Judge. Also, I would request that you put this on your list to the DA too. Thank you.
All right. Any contact with I think it was Officer Brand from the jail?
Not to my knowledge, Judge. She's been in custody the whole time.
Yeah. Ms. Rivera?
No contact, Your Honor.
All right, go ahead, Ms. Jackson.
Judge, the state would oppose reducing this by half. A reading of the warrant says that and I'm sorry, I'm just going to call him Mr. Richard, and I apologize, sir, did approach a detention officer at the jail from behind, repeatedly punching him in the head. The officer did end up having to miss multiple days from work. He did sustain a neck injury and a broken tooth. The allegations that have, as Ms. Safarazi said, been indicted at this point are violent in nature as well. He's got a false imprisonment that initially got him in jail, and while there, he attacked the detention officer. Judge, I know we talk a lot about fights in the jail, but this isn't just a fight. This is an attack on a detention officer. And so the facts of that case just further show that Mr. Richard is a danger to the community, both inside and outside of the jail. He is a danger to the victim if the victim has to continue to work in that place. He's likely to reoffend by having a history of violence. And Judge, we would ask that the bond stay as is.
Judge, I would just note that since this incident, it's been almost a year and he's had no other incidences, no other allegations of any violence. And you could double check with South Annex deputies because he's been at South Annex since then. So the last year, not a single incident, Judge.
All right. We got no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay out of Fulton County unless you're here for court or to see your lawyer. That's the only reason you come to Fulton County, sir. Don't stop and get snacks. Don't stop and get gas. Fill up with gas and all that before you come to Fulton County. No further contact and no further violent contact with any correction officer or law enforcement officer, especially Officer Brand, B-R-A-N-D. I think I already said no drugs, no alcohol, no weapons, no replicas of weapons. Of course, I know you're at 254 Peachtree Street, but you got to stay away from there once you get out, okay? So once you get out, which I'm sure you're like, Judge, I will stay away from there, but don't go back over there, okay? Once you get out, unless obviously they make you go there, all right? You're going to have a 24-hour curfew, court, lawyer, medical, but you can't come to Fulton County except for court and to see your lawyer. Is he going to get employment, Ms. Safarasi?
Yes, Judge.
All right, and employment. You have to supply the name of your employer, proof of employment schedule, and the exact location you'll be working. So I'll do $10,000, $10,000, $250, and $4,000. 10, 10, 250, and 4. I'll put this on my list. Thank you, Ms. Safarasi.
Thank you, Judge. And make sure I'll come out and see you, okay?
All right, and that's it. Thank you, sir. Thank you, Ms. Jackson.
Yes, thank you, Judge.
Thank you, Ms. Jones. Thank you, LT. All right, need anything, Mr. Dukes?
What happened with 13? Mary.
13 was removed.
Judge,
Yes.
I had this quick question. I have 2 consent bonds. I sent them to Judge Brooks, but they haven't even responded. Could I send them to you?
Yes, ma'am.
All right, thank you, Judge.
Okay. Yeah, a bond was dressed on August the 7th with him. Classic.
Okay.
All right, thank you.
And Judge, I'll just forward the email from Judge Brooks too. That way you see the whole chain as well.
Okay, that's fine.
Somebody say something in the background?
Yeah, I wanted to allow
Is that Megan Eustace?
I think that's a judge. What's her name? Judge.
Yeah, that's exactly right. She was my law partner for like 12 years, but she can't remember my name.
Oh, Hughes.
Bostic.
That's the one. Hey,
Bostic.
guys, great night. Come to sign orders.
Thank you.
Woo. Bye.
Right. All right, Bostic, you ready? All right, this is gonna be, Ms. Jones, we're gonna take positions 1, 2, and 3. Marvell Shearer. Position 1, 23, CP 216342. 546 days without indictment. As of April 23rd, there is a $275,000 good bond. Hijacking motor vehicle, first degree, armed robbery, ag assault, possession of a firearm or a knife during the commission of a felony, possession of a pistol or revolver by a person 18 years or under, first offense. Position 2, 24 PI 000247, 546 days without indictment, $230,000 good bond. You got entering auto with intent to commit a theft or a felony times 23. Then position 3 is 23 CP 216401, entering auto with intent to commit a theft or a felony, a $10,000 good bond as of April the 23rd, 546 days without indictment. Wow.
3 cycles, open case 24 SC 201112, street gang, 3 counts, armed robbery, hijacking, ag assault, firearm during theft by taking. Signed to Judge Barwick, has a hold for larceny out of Decatur from 3/22/23. Nothing further.
All right, go ahead, Ms. Rondon.
Yes, Mr. Scherer is 19 years old. He is a lifelong resident of Atlanta, and he does have all of his family here, including his infant child. The address on file is a good address for him where he would reside with his parents. He does also have a job lined up to work at his uncle's company, Happy Paws Inn. That's just waiting for him to be released from custody. As Your Honor stated, he's been in custody without indictment on these cases for 546 days. Pretrial reported he has no felony convictions. He has no failure to appear. He is not a flight risk to leave the jurisdiction, as he has spent his entire life here. He has all of his connections here, and he is waiting for his day in court to address these charges. I'll start with position 1, which is the case that ends in 342. He has a $275,000 bond, which is tantamount to no bond for someone of his age and means. I would ask for the court to consider a substantial reduction in that bond. Again, due to the time he's spent in custody, those 546 days. I would ask for bond not to exceed 50,000 across all, let's see, that's 6 charges. For position 2, the case ending in 247, the 23 counts of entering automobile, I'm asking for bond to be set at $1,000 a piece. So that is a total of 23,000 for that case. And then for position 3, which ends in 401, that bond is currently set at 10,000, and I'm asking Your Honor to consider reducing that to 1,000.
All right, let's see. Has there been any victim contact? Where's my Miss Rhodes?
Yes, in the first case, position 1, we contacted Miss White. She said she's against bond and she still fears for her life. I believe she said she would try to get on the Zoom, but I don't see her on it. And then in the third case, the last contact we had was June 8th of 2023, where we spoke with the victim. And it was about a preliminary hearing, and he bonded felt the same way.
All right, 2 South, booth 3, come in and have a seat. 2 South, booth 3, come on in and have a seat. Go ahead, Ms. White, Mr. White.
Judge, this defendant, as pretrial pointed out, has an indicted case 24 SC 001112, which is in a no bond status. To say that there's 547 days on these cases is something of a misnomer. He has been in custody for a total of 547 days, but when you look at the bond orders, it's, it's due to the fact that he has these 3 unindicted cases. He has this, in fact, indicted what amounts to a capital case, especially given the fact of these unindicted cases. Judge, whatever the court does today won't affect, he's not going to get out of jail due to the indicted case. Also, he's a certainty to reoffend when he's eventually released from custody. And unfortunately for all of us, he will eventually be released from custody, even if he's convicted of the offense currently pending in Judge Barwick's courtroom. He's a very significant danger to basically everyone in the community, especially to his victims. He's a danger to the community as a whole. We'll note that the site of the 23 entering autos is 2 Porsche Drive in Atlanta, or rather, I guess, Fairburn, technically Fulton County, Georgia. Judge, there's just no set of anything that this court could order that would either keep the community safe or ensure that he will be back in court. Also, there's nothing that this court can do today that will affect his status as far as getting out of the jail. The state is opposed to any change at this time, as basically anything the court does would be moot as soon as the court acts, nothing further.
And he's gonna live in Fulton, right, Ms. Rondon?
Yes, I believe so.
Okay, you gonna live in Fulton County, sir? Thumbs up or thumbs down? All right. Okay, on position 1, ending in 342, no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay away from 1001 Ponce de Leon Avenue. That's the Publix, and stay away from all Publix grocery stores. I got must reside at 763 Arshire Circle, AYRSHIRE Circle Northwest in Atlanta, 30318. Is that where you're gonna live, sir? Thumbs up. Okay, got a thumbs up. All right. If there's an ankle monitor available funded by the county, you're going to have a 24-hour curfew. Even if that ankle monitor is not available, you're going to have a 24-hour curfew. The only reason you leave your house is court, lawyer, and medical reasons. Court, lawyer, and medical reasons. No further contact with Kimberly White, WHITE. Also, let's see, I'll do 60,000, 40,000, 60,000, 40,000, and 20,000. Position 2, ending in 0247, the 23 entering autos. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay away from 2 Porsche Drive in Hateville, Georgia. Also, if it's available, you have an ankle monitor funded by the county, but if it's not, then you still have a 24-hour curfew, and the only reason you leave your house is court, lawyer, or medical purposes. Must reside at 763 Ayrshire Circle, Northwest in Atlanta, 30318. I'll make that 7,000 per count, so that's 23 times 7. Position 3, ending in 6401. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. No further contact with James Berry. Must reside at 763 Ayrshire Circle, Northwest in Atlanta, Georgia, 30318. You'll have an ankle monitor paid for by the county if those funds are available. We're kind of running out of those. So if they're not, you still have that 24-hour curfew. The only reason you leave your house is court, meet with your lawyer, and medical appointments. Let's see. Also, no further contact with James Berry. $7,000 good bond. Best of luck to you, sir. 4 North, book 3. Have a seat. 4
Thank you,
North.
Your Honor. That concludes my business for tonight. May I be excused?
Yes, ma'am. Have a good evening.
Thank you. You as well.
All right, ACDC, you're next, but Cobb only has 1. He's got to get back. All right. Position 7 is, wait, Ms. Guest here? Maybe not. Oh, yeah, Ms. Guest is here. 24 PI 001731, 162 days without indictment. There's a $6,000 good bond as of March the 14th. Got theft by taking, possession of tools for a crime, and financial transaction card theft. Wow.
Judge, in regards to the defendant, Holes and Folkestone, 10/22/19. And then the probation violation, Brookhaven 523-24, misdemeanor theft by taking in 24, misdemeanor CWAC in 22, 7 cycles in Florida, FTA in 23, petty theft in 23 and 21, 9 cycles out of Georgia, FTA in 23. Don't look like there's any felonies. Nothing further.
All right, go ahead, Ms. Guest.
Yes, Your Honor. Ms. Bostic, I want to just confirm, did you indicate that Mr. Jackson has holes?
Two.
Ms.
But one of them is old and the other one is probation, a violation out of Brookhaven.
Okay, thank you. Yes, Your Honor, Mr. Jackson is 23 years old, and prior to this incident, he had been living in Georgia for the last 2 years. He does have an extensive amount of family in the Atlanta area, but I have spoken to his father, and it's my understanding that once Mr. Jackson is released, his family does intend for him to go back home with his father in Florida. We have been working with his dad to see what we can do about making that happen. I think there are some issues with Mr. Jackson not having possession of a identification, any identification, which is making it difficult for them to actually post a bond and get him on a Greyhound. But we would like the court to know he does intend to return back to the state of Georgia for any future court dates, if given the opportunity to get a bond that his family could make. Prior to being incarcerated on these charges, he was working warehouse jobs and locally doing lawn work for different individuals. Your Honor, given his limited history, no felony convictions, we would ask that the court considers a reduction in the bond. He has been in custody for over 160 days without an indictment. We're asking that the court considers a $500 bond on the theft by taking, a $1,000 bond on the tools for commission, and a $1,000 bond on the financial card transactions, Your Honor.
All right, what says the state? Has there been any contact with the victims, Courtney Smith and Kenneth Stokes?
Looking now, Judge.
Okay.
Your Honor.
I don't,
right.
I don't see that we've established any victim contact.
All right, go ahead.
Okay. Judge, he's got a $6,500 bond. He's been in basically what,
162 days.
5 months. No, not even that. Yeah, a little over 5 months. A $6,500 bond, given the facts of this case, is and given the fact that he has 7 cycles, he managed to pick up 7 cycles in, if the defense counsel's representation was accurate, less than 5 years in Florida. And then he moved up here and picked up additional offenses up here almost immediately upon arriving in Georgia. He's a certainty to reoffend when he's eventually released from confinement. Whether it's here or whether he is released and then returns back to Florida to prey upon the good citizens of the Sunshine State. Judge, the state is opposed to any reduction in the bond, would point out that at 5 months, there's still 7 months to go, or 6 months, even if you go that far, there's still 6 months to go before there's even any presumption of prejudice due to the fact that he has been in jail without an indictment. Also, the state has 3 years and 7 months to indict him because he has a bond, and the statute of limitations is 4 years on these cases. It's not that the state has been negligent or anything close to it. It's that we have a very dangerous criminal locked up, and he does have what is certainly a reasonable bond, given the felonies that he is alleged to have committed. And the fact that he is a very real danger to the community and not likely to reappear if he's released prior to trial. Nothing further.
All right. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay away from 25 Park Place. Stay out of Fulton County unless you're here for court or to see your lawyer, sir. You don't even stop and get gas in Fulton County. You get snacks, you put your snacks in your car before you ever darken the doors of Fulton County. So don't get a flat tire or anything. No further contact with Courtney Smith. No further contact with Kenneth Stokes. Stay away from all Georgia State University property. And some of that's over on Georgia Tech. So if somebody's wearing a Georgia State University t-shirt on, consider them somewhere around Georgia State University property, which is in Fulton County, so you shouldn't have a problem doing that. Got 750, 1,500, and 2,000. 750, 1,500, and 2,000. Best of luck to you, sir.
Your Honor, that concludes my matters with the court. May I be excused?
Yes, ma'am. Have a good evening. Have a good weekend, Ms. Gibbs.
You do the same.
All right, let's see. ACDC, is this Amber Ford?
No, this is actually going to be position number 4, Fulgham, Jasmine. Thank you,
Okay,
Judge.
gotcha. All right, well, let's see. I don't see him here. But I see Mr. Hines here for Miss Ford and Mr. Jackson.
This is going to be number 5, Miss Ford.
Okay, Amber Ford, Mr. Hines, position 5, Bostic 23, CP 223410, 218 days without indictment. Theft by shoplifting, there's a $500 good bond as of March the 15th, 218 days without indictment. Wow.
Judge, she has a hold from the FTA out of Valdosta, no convictions. There's originally a pretrial. You can put her back on pretrial, Judge. She's been in long enough on this.
Go ahead, Mr. Hines.
That would be my request, Your Honor. Miss Ford is a 38-year-old woman. She's a lifelong resident of the state. She's accused of stealing 2 hoodies. She's been in a total of 219 days on these charges. If she could make this $500 bond since March 15th, which was exactly 5 months ago, she would have. I'm basically begging you at this point to follow pretrial's recommendation and give her a UJR. Thank you.
Where's she gonna live, Mr. Hines?
I think that you, Ms. Ford, you can indicate with the thumbs up or thumbs down, but I think because the hold is gonna come get her and she has family down there, she's gonna stay down there, at least initially. That's where her kids are.
All right, Bostic, y'all still let her report virtually?
Yes, Judge.
Okay, all right, go ahead, Mr. White.
Judge, given the fact that this is in fact a bond surrender from pretrial, due to the FTA, and given the fact that she does have the outstanding case in Valdosta, she's a very poor risk for bond, and $500 is certainly much more than reasonable. In fact, very, very charitable. The state doesn't see any reason to reduce or change the bond conditions at this point. And if Valdosta wants to come and get her, they certainly are able to. The state is opposed to any change in the bond, nothing further.
All right, no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay away from 3393 Peachtree Drive. That's all Macy's stores, and stay away from Lenox Mall. Stay out of Fulton County, ma'am, unless you're here for court or to see your lawyer. That's the only reason you come back to Fulton County. So, ma'am, you didn't report the pretrial last time. So then did you up in jail? So you know what's going to happen if you don't report the pretrial this time? You're going to end up in jail, and then you might be in front of some other judge who might not give you your very last chance. Bostic, if she doesn't report the pretrial immediately, we'll go ahead. We're just going to revoke her. All right. All right. You got to
Yes, that would be immediately, ma'am. Like if you don't call in and report, they're not going to give you no second chances.
Is that level 1, Bostic?
Yes, Judge.
All right, level 1. She's not playing, ma'am. Best of luck to you. All right, now I've got Jasmine Fulgham. Now I've got Mr. And I'll take you next, Mr. Hines. Just let me get All right, so it's position 4, 23 CP 216866, 98 days without indictment. It appears, correct me if I'm wrong or if I'm right on this, there's a $5,000 split bond, for financial transaction card theft, 2 cases of theft by received and stolen property, misdemeanors. Jasmine Fulgham, 98 days without indictment. Wow, that's of 6-6.
Fulcrum, hold from FTA out of Boulder, but it's from 2016, which means they're not gonna come get her. FTA in 24, given false name in 2019, battery and obstruction of simple battery of police officer 2018. No prior felony convictions, it appears. Nothing further.
Go ahead, Mr. Masurgeon.
Thank you, Your Honor. Ms. Fulgham is 29 years old, lifelong resident of the state of Georgia. As you heard, no felony convictions. At this time, she previously had a UJR, and we unfortunately had some issues with pretrial services. So at this time, Your Honor, we're just asking for a reduction in bond to $1,000 total, so that we can seek assistance through the bail project at this time. Thank you, Your Honor.
She gonna live in Fulton County?
Her previous address I have is in Norcross. I'm pretty sure that is where she's going to return to in Norcross.
I don't think that's Fulton County. Go ahead, Mr. White.
Judge, I'm just trying to. Okay, Odyssey's not making a whole lot of sense as to what I'm seeing. Judge, certainly, and the euphemism, some problems with the pretrial is interesting. It's only been 98 days. She has a bond. There is no possibility of prejudice. There's not even been an attempt to say that there's been any change in her circumstance regarding the bond. Judge, this is not a case that, I mean, kind of my response is like, really? Judge, the state is opposed to anything to disturb this bond, this very, very fair bond, after such a short period of time as is the case in this matter. Nothing further.
All right, no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay away from 16785 Old Morris Road in Alpharetta, Georgia. No further contact with Cecil Anderson, Karen Kahn, Kahan, and King Sims, Simms. Stay out of Fulton County. Don't
Hey,
leave.
Judge, sorry to interrupt. I'm just reading the notes. Issue is, okay, blah, 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 blah. Here's what the problem was. I think she got a signature bond with a hold when she was initially got the signature bond. She had a hold of Clayton County. She was sent to Clayton County jail, which is the reason why I always say don't give somebody a signature bond and they have a hold. So when she was released from Clayton County, she didn't report. After she was released, and then I guess they couldn't get in contact with her, and I guess that's why we did a bond surrender on her.
4 North, booth 3, sit up straight.
So if you wanted to reinstate, that is fine. She just needs to report now, because she never reported after she got out of jail from Clayton County.
Mr. White?
Judge, the fact that she never reported is at least as much indication that that she's not able to follow the directions of this court as it is, you know, an indication that there was some kind of confusion. The state would also point out that under OCGA 17-6-12, open paren, Victor, close paren, a national transaction card theft is not a UJR eligible offense.
All right, so let's see where to lay off. Yep, stay out of Fulton County. Don't reach to come back to Fulton County's court or to see your lawyer. So here's what we'll do. We'll do 1,000 UJR through pretrial level 1, UJR through pretrial level 1. And we'll do it through the sheriff 10% program. Best of luck to you, ma'am. Don't let me see you again. All right, James Jackson. All right, Mr. Hines is position 6, Bostic 24, PI 001694, 161 days without indictment. Let's see, what is it? It's a $25,000 good bond as of June 18th. I got simple battery, criminal damage to property in the second degree, and burglary in the first degree.
In regards to Mr. Jackson, 2 arrests in Pennsylvania, 11 in Georgia, open case 23 CP 221312, theft by taking, 23 battery family violence FTA in 2018, a battery in 2020, a battery in 2020. He has a history of violent arrests, nothing further.
And it appears this is the same victim on the previous domestic violence. Go ahead, Mr. Hines.
Yes. Yes, Your Honor, thank you. Mr. Jackson is a 34-year-old man. He has a good address living in his family home in Fairburn, where he lives alone. He's a lifelong resident of Atlanta and the metropolitan statistical area of Atlanta, and he's never lived anywhere else. His whole entire family's here. He was employed in the food service industry at the time of his arrest and will return to that work. And he also has a job still waiting for him, actually, in roofing and flooring, which work he's done for literal decades. He's a high school graduate and does have 2 years of college to his name. His criminal history, as you heard, is relatively short. I would submit on cycles, but even shorter on felony charges, even shorter than that on felony convictions.
Excuse me, Mr. Hines. 4 North, booth 3. Sit up straight. Go ahead, Mr. Hines.
So I was saying his cycles are even shorter on felony arrests and even shorter on felony convictions, as he has none. He's, of course, he understands the court can impose any stay away provisions that the court wishes. However, the alleged victim would prefer nonviolent contact. And the alleged victim is here, Ms. Bly, in full support of Mr. Jackson. I've spoken with her on the phone. I've spoken with her in person. And I do have an email saying she doesn't want this prosecution to continue. I provided that preliminary hearing. I provided that email at the preliminary hearing to Judge Brooks. And in that email, Ms. Bly explains that some of the misunderstanding and how it seems like what happened might have been an issue of the cop running with what Ms. Bly said, but not actually understanding what she was saying. And that's part of why Mr. Jackson was, unjustly arrested for home invasion when it clearly wasn't a home invasion. And now that charge was dismissed and turned into a burglary, even though this is a place that he lived at the time. So just to be clear, because the warrants do mention them, and you might be looking at the warrants and you didn't have the benefit of being at the preliminary hearing like I was, I want to be clear, Ms. Bly saw no knife and there was no knife. Ms. Bly also says that the alleged door damage cost her nothing to repair, and the building maintenance fixed it with epoxy glue. Again, she's here in defense and support of Mr. Jackson, and she's been at all of his hearings. As I said, we've spoken in person and on the phone, through text and voice call. Having been incarcerated 161 days, even though he has a job waiting, his ability to pay a bond has been severely curtailed. And because pretrial surrendered his bond on this simple theft case that hasn't been indicted from 2023, he now has to pay on that $10,000 bond as well. So given having to pay that bond, given him being a lifelong resident with absolutely no felony convictions, given him having a long-standing, strong employment history, college under his name, and the avid, fervent support of the alleged victim, I'm asking for his aggregate bond in this case to be reduced to $3,000. Thank you.
Mr. Hines, where's he going to live?
At that house in Fairburn. So I'm not sure if that's like.
So I got one. All right. So I got one question for you, Mr. Hines. So the 23 CR 00, I think it was 3916 D as in David. Time served, 12 months probation. There was no further contact with this alleged victim. However, this incident date was January the 16th, 2024. So what's your position on that when he wasn't supposed to have contact with her?
Wasn't he sentenced on that after the date of this?
Well, there were bond conditions previous, though, I'm saying so.
Well, I would just say that case law, if this were a hearing and I provided the case law and the context of any alleged conversations, it's a defense that if someone consents or initiates a conversation, that you can, quote unquote, violate a no contact order.
Go ahead, Mr. Go ahead, Mr. White.
Judge, this is the fourth case involving this same victim. And in reading through the previous three cases, what we're seeing here is an escalation of violence every time there's contact between this victim and this defendant. I understand that the victim is at this point saying that she wants contact with her abuser, but that is unfortunately something which the court is aware is very, very common, especially when someone has been subject to an escalating pattern of abuse and violence, which is what we're seeing here. Judge, this defendant is extremely dangerous to his victim, and also becoming more and more dangerous to the community as a whole, as is evidenced by this case. Also, it's interesting that it would be characterized as, oh, well, the victim wanted or initiated the contact, when even by the victim's most favorable statement about this defendant, the door had to be repaired. In other words, it's really interesting because I've rarely, if ever, known a victim to initiate contact where the defendant kicked in the door. That's actually strange credulity at best. Also, the fact that this defendant is claiming to be a lifelong resident of Georgia with arrest cycles in Philadelphia sort of causes me to scratch my head as well. Judge, given the fact that this defendant is an increasing danger to his victim and is very, very likely to reoffend if the dates of his previous arrests are any indication, almost immediately upon being released from confinement. Judge, the state is opposed to any change in the bond, and in fact, would suggest that the more prudent action for this court to take at this time would be actually to increase the bond probably by tenfold, nothing further.
No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay away from 8350 Roswell Road, Sandy Springs, Georgia.
Your Honor, for the record, I would like to rebut on my motion.
Okay.
Okay, because my client is being maligned and upbraided by the prosecutor, who I'm sure has not talked to the alleged victim. There is no escalation of violence. He's not charged with any violent felony in this case. He never has been. He's charged with a misdemeanor, and the allegations are very minor. I take issue with him being characterized as an abuser. And the paternal, I understand the state so-called has a charge to protect the community, but its paternalistic arm can only go so far. He keeps referring to her as the victim. She's right there. Her name is Miss Shine Bly. And you can essentialize her as a victim. The state can essentialize her as a victim all they want and say, oh, victims do this and they recant. And generally, you haven't talked to Miss Bly. You don't know the complexities of her life and the actual things that she said. You just come to a bond hearing and try to keep somebody in prison. You weren't at
All right, so let's stick to the Ayala. That's what
Ayala, he's a lifelong resident of Atlanta. He has no felony convictions, and he's not a risk to harass or intimidate somebody who wants contact with him. Thank you.
All right, no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay away. Absolutely stay away, sir. I don't care if you're invited to 8350 Roswell Road in Sandy Springs, Georgia. And absolutely no contact with Sean Blythe. This concerns me because this arrest when you're out on bond, so you can't accept any phone calls from her. She can't invite you over. Ms. Blythe, 27,000 domestic violence TPOs. I know domestic violence. You may not consider yourself a victim and you may not be concerned for your safety, but I'm concerned for your safety, ma'am. So you go absolutely nowhere around her, sir. You're going to have a 24-hour curfew, court, lawyer, and medical is the absolute only reason you leave your house, and you cannot live with her. 4,000, 4,000, and 12,000. Best of luck to you, sir. You can leave the booth. All right. What about?
Thank you, Judge.
Let me see it, Mr. Hunt. You just got one more, right? Let's see. What about Emmett Lloyd? Wave your hand if you're Emmett Lloyd. There we go, Mr. Lloyd. Sit up straight so Mr. Hines can see you. Outstanding. Position 11, 24, PI 003573. 88 days without indictment. There's a $12,500 good bond as of June the 12th on ag assault, one count of cruelty to children in the first and one count of cruelty to children in the third. Ah.
18 cycles, old burglary of 2012, entering auto 2016, ag assault, nothing further.
Go ahead, Mr. Hines.
Thank you, Your Honor. Mr. Lloyd is a 35-year-old man. He's from the great city of St. Louis. That's where I went to college. But he's lived in Atlanta for 18 years, which is over half his life. He has a good address in the 30354. He has one child, a 16-year-old daughter whom he adores. He's a high school graduate. He works in landscaping and will return to that work on bond. Mr. Lloyd does live with diabetes. As you heard, he has a number of cycles, with his last arrest being over 2 years ago, but only 2 of those cycles are felony convictions, a burglary from 2009 and an entering auto from 2012. Both of those, Barack Obama was still the president. I was in college. Both of those are outside of the usable 10-year window. Given Mr. Lloyd's longstanding ties to this community, the context of his criminal history, the context of these allegations, which he vehemently denies, and which the preliminary hearing showed that the so-called complaining witnesses did not have as many opportunities to make the observations they claim they made. So he vehemently denies these allegations, and he will vigorously defend against them. I happen to know that the mother of the alleged victim has texted me and said she wasn't allowed into the Zoom yet, and I do not see her, but I have talked to her constantly, and she is in support of Mr. Lloyd. Those are like stepsons to him, and they don't oppose contact with him either. I'm asking for a bond of $3,000 total. Thank you.
All right. Go ahead, Mr. White. No.
Judge,
Oh,
Mr.
let me ask Ms. Rose. Ms. Rose, any contact with the alleged victim?
We contact her via email. We sent her the Zoom link as well. She said that she would try to make it, but I don't see her in the Zoom either.
Go ahead, Mr. White.
Judge, interestingly, the defense counsel's presentation failed to mention the 2016 aggravated assault conviction for which this defendant his probation, he had a probation violation in 2018, making him a C recidivist in the state of Georgia, meaning that his very next conviction will require, provided that the state files the demand that this defendant be sentenced for the maximum possible time allowable by the sentence. This defendant is potentially going to prison for a long, long time, given his extensive criminal history, given his fact that he does have violent crimes in his past, given the fact that this has only been 88 days. I'm not even sure why we're here, reconsidering a bond order that was given back only in June, on June the 12th of 2024. What that only makes, 65 days since the last bond order. And certainly if he were in a no bond status, he wouldn't be entitled to a bond today. So there is frankly no reason that we're here. This bond is certainly much more than fair, only being a $12,500 bond, given the fact that it's an aggravated assault with someone with a violent history. The state is opposed to any reduction in the bond, and yeah, I mean, there's no possibility of showing a prejudice, just nothing. There is no reason to change this very, very favorable bond that was given only 65 days ago, 63 days ago, nothing further.
All right, no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay away from 3114 Latonia, Lotona, Latana Drive Southwest. No further contact with Electra Crowder, Crowder, Nemaya, and Isaiah Wilder, excuse me, Nehemiah, and Isaiah, Isaiah, Wilder, Wilder. All right, you're gonna have I don't think there probably won't be any ankle monitors. If they are, you'll have one placed on you. If it's not, you still have a 24-hour curfew, court, lawyer, medical, and he's gonna have a job, Mr. Hines.
Yes, Your Honor.
All right, employment, you have to supply the name of your employer, proof of employment schedule, and the exact location you'll be working. 7,000, 2,500, and 2,000. Best of luck to you, sir. You can leave the booth. Thank you, Mr. Hans. Have a good weekend.
You too. Thank you, Your Honor.
Jason Nesbitt. Wave your hand if you're Jason Nesbitt. There we go. All right, Mr. Nesbitt, it's position 8, Bostic 24, PI 002-357, 91 days without indictment. And let's see, there's a $6,500 good bond as of June the 6th, 2024 on, let's see, fleeing, attempting to elude a police officer, possession of sawed-off shotgun, sawed-off rifle, machine gun, dangerous weapon, or silencer, theft by receiving stolen property, window tint violation, reckless driving, and marijuana less than an ounce. I don't think I missed anything. Right.
7 cycles, entering auto, 8 counts, probation at 11/29/23, 5 years. Rockdale entering auto, 5 counts in 2022, FTA in 24. Nothing further.
And Mr. Mercergent, there was a bond surrender. It was filed May 24th. It was filed again in August. It's the same bond surrender. So I'm assuming, and I hope you're going to help me out, that $6,500 good bond is still the bond we're dealing with.
That is my understanding. That's what the bond is right now.
All right, go ahead.
Thank you, Your Honor. Mr. Smith is 21 years old, a lifelong resident of the city of Atlanta. He has a good address off Lake Drive. That's the address on file. Lives there with his mother. He has been in custody now 93 days and on this bond that he currently cannot afford. In addition, he does have the VOP hold that we're waiting on. Or I'm sorry, Your Honor. His address is in Conyers, but he does reside there with his mother. At this time, Your Honor, we're asking for the bond to be reduced, cut in half to $3,250 at this time, so that we can seek bail assistance if necessary while we work on getting the holds worked out. That's all, Your Honor. $3,250 at this time.
Go ahead, Mr. White.
Judge, he's been in custody less time now than there was time between the final disposition of the 23 SC 188008 case and the commission of the new offense. The state would point out that the new offense, the firearm, and hang on, I just want to make sure that I'm getting it exactly right.
Did it have one of those switch mechanisms?
It's a Glock switch, which is converts, as the court is aware, converts a semi-automatic handgun into a fully automatic machine gun. So here we have a fully automatic machine gun. I don't see that there was an extended magazine with this machine gun, but the conversion renders a standard Glock able to spit out an entire magazine in about 2.5 seconds. There's only one reason to have a fully automatic weapon that's as easily concealed as a Glock, and that is that you intend to kill people with it. It's a people killer, plain and simple, and there's no other reason to have one. Judge, this is a very dangerous individual. As was stated, he's picked up not one, but 2 felony convictions in less than 2 years since his age of majority. And he violated his probation with this offense. Judge, he's not a good risk for bond. He certainly, I don't know how he got a $6,500 bond. It should be a minimum of a $65,000 bond, if not higher, just for the protection of the community. We already know he's not going to obey any of the orders of the court, and that he is a certainty to reoffend when he's finally, eventually released from custody, as he unfortunately will be. Judge of State is opposed to any change in the bond, any downward departure in the bond, would request that because the court has been asked to reconsider bond, that the court reconsider the bond and reset the bond at no less than $65,000, nothing further.
All right, no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. No driving unless your bond is modified, sir. And stay out of Fulton County. The only reason you come to Fulton County is court or to see your lawyer. You're gonna have an ankle monitor if it's paid by the county, if it's available with a 24-hour curfew, court, lawyer, and medical. That's the only reason you leave your house. And you get snacks, fill up with gas, and do all that before you ever cross that county line when you're driving to court or to see your lawyer. Let's see. $1,000, $5,000, $300, and I'll leave the rest at the UJR. $1,000, $5,000, $300, and leave the rest at the UJR. Best of luck to you, sir. Kevin Davis. You can leave the booth. Kevin Davis, wave your hand, Mr. Davis. Yep, you can leave the booth, sir. All right, position 10, 24 PI 003 424, 92 days without indictment. $20,000 good bond as of June 7th. On aggravated assault, simple battery, theft by shoplifting, and public drunk.
Davis hold for FTA 51424, open simple battery 23 CR 00654 PI in 21, history of probation violations, simple battery, family violence in 22, probation, assault act, battery, cruelty in the third. 2 counts, sentence 52820 for at least 5 years, nothing further.
Is that your client trying to get out of the door?
It appears that way. I'm not sure what's going on in the jail right now.
I'll make a call, Judge.
All right, seat, sir. Have a seat if you want to hear this. All right, go ahead, Mr. Surgeon.
Thank you, Your Honor. Mr. Davis is 28 years old. He's a lifelong resident of the city of Atlanta, has a good address off Carpenter Drive, lives there with his mother, as well as his siblings, Your Honor. Prior to his arrest, he was employed working in fast food. I'm fairly confident he does not have that job at this point in time, but he does have the experience. Your Honor, he'll be able to find employment quickly once he's out. Your Honor, at this time, we're asking for a reduction in the bond. It is currently set at, I believe, $23,000, Your Honor. We'd ask that to be reduced to $10,000 in total. We understand that the prosecution is not happy that we're having bond hearings only 92 days since he's been arrested, Your Honor, but still we would stand on our motion and ask for a reduction in bond at this time, as Mr. Davis can't afford the bond that he has currently.
Is where you're going to live? Is that in Fulton County?
Yes, Your Honor.
All right,
It's
go,
not use.
all right. Go ahead, Mr. White.
Judge, where, gosh. You know, the time between his last release from confinement and this arrest is again less than the period of time that he has been in the Fulton County Jail after this arrest. Judge, this defendant is another, I mean, not virtual, absolute certainty to reoffend almost as soon as he's released from the Fulton County Jail. As was noted by pretrial, he has a long history, given the fact that, you know, if you can have a long history at being born in May of 1995, of failures to appear, he's apparently completely incapable of complying with any order of the court, and he's also completely incapable of not committing a new offense almost as soon as he's released from confinement. Judge, this is a very, very poor risk for bond. The bond is charitable, much more than reasonable. And there is no possibility of any prejudice to the defendant, to the defense. The only people that are
Hold on a second, Mr. White.
given
Mr.
the fact,
Davis. Mr. Davis, do you have any concern over what's going on? He gets up one more time, counsel. That's it, because he just doesn't seem to be interested. Go ahead, Mr. White.
well, Judge, I was going to point out the fact that this defendant's behavior is actually probably the best evidence there is of this defendant's complete disdain for this court system, Your Honor, and frankly, the good citizens of Fulton County in general. The state, as opposed to any reduction in the bond, would suggest that, given the aggravated assault, that the aggravated assault should probably more appropriately be, rather than 16,000, closer to 160,000, and the two shoplifting should be at least $10,000 each. Judge, as the court has discretion to reconsider the bond in any time that it's brought back before it, the state would suggest that probably a $200,000 bond would be the minimum appropriate bond in order to protect the public and possibly have some possibility of ensuring that this defendant showed up and complied with the orders of the court, nothing further.
No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons, no further contact with Michael Macon or Darius Walker. Stay away from 6445 Roswell Road. That's a Waffle House. You're going to stay away from all Waffle House restaurants. Let's see. So, 6445 Roswell Road in Sandy Springs, and also 6401 Roswell Road in Sandy Springs. Also, you're going to have a 24-hour curfew, sir. If there's an ankle monitor, it'll be supplied by the county if the funding's available. If not, you'll still have that 24-hour curfew. Court, lawyer, medical, employment. You have to supply the name of your employer, proof of employment, schedule, and the exact location you'll be working. I'm going to leave it at 20,000. Best of luck to you, sir. Last case for you, counsel. Is it Wagah? Is that how you pronounce it?
Wagah, Your Honor.
Wagah. Okay. Wagah Smith. Number 13, Bostic. Take us home. 24 PI 003444. 93 days without indictment. As of June 26, there's a $40,000 good bond on ag assault, possession of a firearm during the commission of a felony, and reckless conduct. Wow.
Judge, in regards to Mr. Smith, he has 5 cycles, numerous open cases, 24 SC 00274, cocaine misdemeanor possession, Judge Lethbridge, 23 SC 190704, theft by receiving, 22 SC 184423, armed robbery, ag assault, firearm during, 24 PI 002814, ag assault, 24 CR 00307 ordered and prowling FTA in 2020. Nothing further.
All right, go ahead, counsel.
Thank you, Your Honor. Mr. Smith is a lifelong resident of the state of Georgia. He lives in Atlanta with his whole family off of Westlake Avenue, Your Honor. He, as you heard, only has 5 cycles. We understand there's a number of open cases. However, they're all still open, unadjudicated. He has not been found guilty and is presumed innocent at this time on all of those matters, Your Honor. He currently has a $40,000 bond that he cannot afford. If the state insists that he's such a danger that he's surely going to be re-offending or intimidating witnesses or what have you, they have the ability to indict the case. They still haven't indicted it at this point, Your Honor. And the only reason that Mr. Smith is currently in custody is that he has a bond he cannot afford. Your Honor, he will show up to court. He has those cycles, but I didn't hear any FTAs. So at this time, we're asking for the bond to be cut in half down to $20,000.
Any contact with the victim, Ms. Rhodes?
Yes, we were able to contact Mr. Booker. The victim fears for his safety and the community's safety. He does not know the defendant personally, and he said he wasn't injured during the assault, but was scared.
Go ahead, Mr. White.
Judge, I'm just looking at the armed robbery that was indicted. That's 22 SC 184423. And it looks like that is a $90,000 bond that was set on that one. So contrary to the defense counsel's representation, this isn't really what's holding him in confinement. There is the bond in that one. There is also a bond in, hang on. There's also a bond in 23 SC 190704. It's apparently holding him in. As well, there's this case, and then there is another aggravated assault, open aggravated assault from April the 1st of this year. Or is that, wait a minute, maybe there's just, he has so many offenses, I'm getting a little bit confused as to which one is what. No, there's the other one that's holding him is 24 PI 002814, which is an aggravated assault from April the 18th of this year. And it looks like the bond order for that one is also an additional $5,000 bond. Judge, this defendant is a very violent criminal, and the only reason that, also I would just point out that he has a possession of cocaine indicted under 24 SC 002274. He's just committing offenses faster than we can actually dispose of the cases. Releasing him on bond is just tantamount to allowing him to pick up another case. And so then he will have not 3 indicted cases and 3 unindicted cases. He'll then have 3 indicted cases, or maybe 4 or 5 indicted cases, and yet another unindicted case. Your Honor, the state is opposed to any change in the bond, especially a downward departure in this case. It's not like he's not been indicted. It's not like he's not before the court, Judge Leffridge, on the open cases. It's just that he is so likely, in fact, certain to commit another offense, apparently within days of being released from confinement, that when he's released, eventually he'll be right back to us. Judge is a danger to the community. He's a certainty to commit new offenses. The state is opposed to any change in this bond in this case. Nothing further.
Counsel, is he gonna live in Fulton County?
Yes, Your Honor, he will.
All right, no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons, no further contact with Crowell, Crowell, Booker, Boocker. Stay away from 37 Lyndhurst Drive, Atlanta, Georgia. You have a 24-hour curfew. If there's an ankle monitor available, the county can supply it, but we're running short on funds, so it may not. You still have that 24-hour curfew. Court, lawyer, medical. Is he gonna get a job?
Yes, Your Honor.
All right, employment, as long as you supply the name of your employer, proof of employment schedule, and the exact location you'll be working. 30,000, 5,000, and 4,000. Best of luck to you, sir. Thank you, Joe. Hope you guys have a good weekend.
Thank you, Your Honor.
Thank you, Judge.
Thank you.
That's all I got. So technically we're at this point. That point right there. Ladies and gentlemen, thank you so much for coming out tonight. It's been fun. Don't forget Saturdays, noon Eastern time, 11 Central Standard Time. We do our weekly roundup where I just show a lot of cases, kind of a weekend gallery of fun, and I don't know about fun, but interesting cases, if I do say so myself. Come by, check it out. I enjoy doing it. I'll be dropping new cases almost every day this week, so keep an eye out for the videos dropping every day. And I will see everybody same Manning time, same Manning place next week on Manic Monday with Judge Manning at 7 p.m. Central Time, 8 p.m. Eastern Standard Time. Love all you guys. See you next time, all right? All right. I'm starting music here and it's not coming on. There we go. Right? There we go. That's it. That's it. See you later, music. All right, kids. All the important things. All the important things. Saturday, noon Eastern, 11 Central. Monday, Manic Monday at 8 p.m. Eastern Standard Time, 7 p.m. Central. You know, all the things. Don't forget all the other great channels out there. You know, Collins of the world, the Mikes of the world, the Court Vibes of the world. Show some love to the community. Court Tube community loves you all. And without you, we're nothing. See you next time. Are there people still here? I thought we've had this discussion before. I'm not going to do a Ferris Bueller Days Off style end of show thing every show. I'm not going to do it. Not a thing I'm going to make common. So go. Get. Dude, we're done here. The show's over. See you on Saturday. Come back Saturday. Definitely come back next Monday. We're gonna do more of this next Monday. Go. We're done here. Go get some Mexican food or something. Good night time.